Good morning, everybody. Welcome to this webinar on algorithms and accountability, safeguarding human rights in the age of artificial intelligence. This event is co-hosted by the Human Rights and International Law and Technology interest groups of the American Society of International Law. Our conversation today will not focus on complicated computer science terminology, such as large language models, neural networks, or GPTs. Today, we're going to talk about how this new disruptive technology affects our everyday lives. We are going to talk about fundamental rights and the risks involved in the use of AI. My name is Francisco Quintana. I am a member of the Human Rights Interest Group of the American Society of International Law. Today, I have the privilege to moderate this panel. Let me briefly introduce our speakers today. Professor Nathalie Smuha, she has just started this month her work as Assistant Professor of Law at the University of Toronto. Her research explores the intersections of international law, philosophy, and technology, with particular attention to the impact on human rights, democracy, and the rule of law. She is the author of Algorithm, Rule of Law, How Algorithmic Regulation in the Public Sector Erodes the Rule of Law, and the editor of the Cambridge Handbook on the Law of Ethics, Policy, and of Artificial Intelligence. Both books were published by Cambridge University Press this year. She has taught in 11 Faculty of Law University in Belgium, NYU, Columbia, Chicago universities in the US, and Birmingham universities in the UK. Besides her academic activities, she coordinated the work of the European Commission's high-level expert group on artificial intelligence and has participated as an expert in the Council of Europe, the OECD, and UNESCO. Professor Chander from Georgetown University is an expert on the global regulations of new technologies. A graduate of Harvard College and Yale Law School, he clerked in the Second and Ninth Circuit Courts of Appeals. He practiced law in New York and Hong Kong, and he has taught at Yale, the University of Chicago, Stanford, Cornell, and Tsinghua. He has also served on the Executive Council of the American Society of International Law, where he co-founded the International Law and Technology Interest Group, one of the co-host groups of this event. Among dozens of articles in specialized journals, he authored the book The Electronic Silk Road by Yale University Press. In expert capacity, he has participated in the World Economic Forum groups on the digital economy. I have to announce that due to a family emergency, Professor Margot Kaminsky will not join us today. So we have decided to divide this conversation in 3 blocks. In the first block, we are going to talk about the legal framework of artificial intelligence in the European Union and in the United States. This will give turn to the second block, where we will talk about human rights, how they have been protected in the European Union, how democracy has been strengthened, at least in the treaty, and how the US has reacted in this new administration towards the protection of fundamental rights and how to handle risks. And at the end, in the third block, we will make a comparison on the risk-based approach and the rights-based approach on artificial intelligence. For participants, you can send us questions through the Q&A section in the webinar, and we will not be looking at the chat for questions. Thank you very much. And now I will give the floor to Professor Nathalie Smuha. Nathalie, can you guide us? What's the current situation of the European Union Act on Artificial Intelligence? The treaty did not come into force completely. Last year, the first section came into force, and only 15 days ago, the second section came into force. What does this mean to the protection of fundamental rights? Nathalie.
Yes, first of all, thank you very much for inviting me to be here. It's a pleasure to participate. And to take on your question, perhaps it's good to just take one step back and talk a little bit about what the European Union has put in place thus far, because not everyone here in the audience might be familiar with the European Union's AI Act. So in a nutshell, the European Union's AI Act is a sweeping and comprehensive AI regulation that tends to horizontally, so across all sectors, regulate the deployment and the development of artificial intelligence in the European Union. But it also means that it applies to US companies, Chinese companies, any other company that brings in its AI systems into Europe, or of which the AI systems have an effect in the European Union. So it does have some cross-border effects as well, which is why lots of transnational organizations will have to deal with it. This is the first of its kind. In a way, Europe is not the first one to regulate AI as such. China, for instance, has been coming up with AI-specific legislation for specific applications, such as recommender systems or deepfakes, even before the EU. But the EU is, I think, the first to really comprehensively regulate it. Now, it's easy to criticize the act, and I've been very critical about it because there is a lot of potential that has not been fulfilled. And it's also a complex regulation. But at the same time, before I move into criticism, I always try to also say that it's much easier to criticize something that is there than something that doesn't exist. And I think the European AI Act is also an easy target of criticism because it actually exists, because European member states actually made the effort to sit together and think of what kind of regulation they want to impose on AI systems, or rather, what kind of society they want to live in, because that's the underlying question. And so I think, regardless of the merits of the regulation, that does deserve praise, because there was a strong signal that there are risks associated to the technology, and that we wanted to make sure that the technology aligns with the values that the EU cares about, and more specifically, human rights is a key element of that. Now, it is a market harmonization regulation. That means that basically the EU has been trying to regulate the EU internal market, right? So as many of you know, the European Union has one market. There should be no barriers between EU member states. And to prevent those barriers, it adopted the AI Act. So to avoid that France, Belgium, the Netherlands, for instance, each have their own AI regulation. So fundamental rights are not at the forefront of the type of the regulation, because it is a market harmonization regulation. However, the words fundamental rights, how we call human rights in Europe, appears at least 100 times in the regulation. So it is very prominent. Even though it's primarily economic in nature, it is also fundamental rights centered. And there are various provisions in the AI Act that protect human rights. So the AI Act is notoriously based on a risk-based approach. And that's something I know that we will talk about further. So I'm not going to dive into the details of what that means. But in essence, there are several categories of AI systems. And each category, depending on the risk it poses, is regulated to a more severe or less extent, right? And so these different categories also reflect human rights protection. So there's a certain category of practices that is prohibited. And the reason that they are prohibited is because in the European Union, studies have shown that these can violate fundamental rights to an unacceptable extent, right? So there can be trade-offs between an infringement of one fundamental right versus another one. But if the risk is deemed unacceptable, it's a prohibited practice. And these practices are exhaustively mentioned in the AI Act. Just an example, AI systems used for subliminal manipulation of people in a way that causes significant harm, or using AI to create a huge facial recognition database, or using AI to infer emotions at work or at school, or using AI to categorize people's race or religion or sexual orientation just through their biometric features. So these are all things that are deemed incompatible with human rights and are thus prohibited. And those prohibitions already entered into force. So this is already since February this year, those kind of systems cannot be used in the European Union. Now, of course, it's not as easy, right? Because you need to be able to show or prove in front of a court that the system leads to harm, right? Or that it falls into such category. It's not that there is a licensing system, whereas even before you can put the system on the market, that someone is vetting that your system is not a prohibited practice. So every developer and user of an AI system themselves needs to assess whether they fall into that category. And then you have the second category, which is probably the core, the bulk of the AI systems regulated by the AI Act. And those are higher risk systems. And they're seen as high risk because they are deemed to pose a high risk either to human rights, to safety, or to health. So here as well, you see that human rights play a fundamental role in deciding what are the kind of systems that we want to regulate. And regulation here means imposing additional requirements. So the set of prohibited practices is very limited, whereas the set of systems posing a high risk is far broader. And these systems can still be used in the European Union. So in that regard, nothing changes. But in order to use them, they need to fulfill certain mandatory requirements before you place them on the market. Again, there's no vetting system. You don't have to go proactively to an authority that checks for you whether the system complies with it, but you actually need to assess yourself whether your system falls under the high-risk category, and then you need to fulfill certain requirements before you can place a system on the market. For instance, you need to put in place a risk management system. So try to understand in advance what are the risks that my system poses and how can I mitigate them. If there's a serious incident, which includes the breach of a provision that protects fundamental rights, you also need to notify the authorities. If you have training data that you use for AI system, we know that training data, if it's biased, if it's not comprehensive enough, can lead to discriminatory outcomes. This is something that you need to test for in advance. You decide how you carry out those tests, but it needs to happen. And you need to document, make the system traceable for better accountability afterwards. And then there is a category of systems used by public authorities. Imagine there's a public authority that uses an AI system to allocate social welfare benefits, or to assess migration, or anything related to public authorities. Well, those authorities, before they can use an AI system that falls under high-risk category, they also need to undertake a human rights impact assessment. So this is, again, a feature where human rights stand central in the AI Act. So the public authority needs to assess in advance how could this system impact human rights and what kind of mitigation measures can I put in place to prevent an adverse impact or to mitigate it to the larger extent possible. There's also provisions on generative AI, so general purpose AI, as the AI Act calls them. If they can pose a systemic risk, if they're sufficiently substantive, they also need to take that into account, document what those risks are, and fundamental rights, the breaches of fundamental rights are also deemed to be a risk. So this is, in a nutshell, the architecture or the skeleton of the AI Act. Now, I have to say it's a very long legislation. Even lawyers sometimes get lost in it. And to comply with it, there is quite some red tape, especially for high-risk systems. So a balance will need to be made also in its implementation between making sure that the provisions meet the goal of better protecting human rights, health, and safety, but also making sure that companies actually manage this, because definitely smaller companies or startups, they don't necessarily have the expertise in human rights to know, okay, if I need to mitigate risks to human rights, what does it actually mean? How can human rights be affected here? So there is also a whole system put in place to try to help these companies and organizations to reach those goals. So within every EU member state, a national authority will be put into place. So this is happening as we speak, and that authority will be enforcing the AI Act together with the European Commission. But at the same time, it's also supposed to help companies to meet these requirements and help them with templates and all other kind of guidelines and material. And finally, in terms of entry into force, so indeed the prohibitions are already into force, and the provisions on generative AI are also into force, but the bulk of it, the high risk systems and the requirements that you need to fulfill, this will enter into force in August 2026. So this will be a big milestone. And that is what we're waiting for. The difficulty will be enforcement for sure, because while for companies and organizations it will be difficult to fulfill the requirements if they're not familiar with the impact of AI and human rights, also for national authorities it will be difficult to hire personnel and to get sufficient resources, because you need people who know both how AI works, but also what human rights are and how they can be affected and what kind of measures can be taken against that. So that will definitely be a challenge. I can indeed talk hours about that. I'm not going to do that right now, but I'll stop here and we'll take it further. Thank you.
Thank you very much, Nathalie. This is a very good introduction to our conversation. Professor Chander, now let's go back to the US. In the US, the new administration struck down Biden's artificial intelligence policies. The vice president told the European Union in February that they should slow down their regulations. Now we have a new artificial intelligence action plan that has no reference to fundamental rights. Actually, the only time the action plan mentioned rights twice, and the first time it refers to the rights of the states. Where is this administration moving forward in terms of protection of liberties and rights of individuals? As Professor Smuha has already mentioned, there are prohibited categories in the European Union. But what about in the US on surveillance? The company Palantir just announced a big surveillance program for migration for the border. Professor Chander, you have the floor.
Great. So just on the Palantir and migration at the border, my understanding is that there's a lot of exceptions in the prohibitions within the European Union's Act. Whether or not they would cut the EU AI Act governs what happens at the border for migrants is something that I'd love to ask Nathalie for further clarification on. So it doesn't obviously cover military applications of AI, and law enforcement has various, differential obligations under it, and the exceptions have exceptions. That is, the prohibitions have exceptions. And so, just a level set on where we're comparing. I'm not suggesting that what we're doing is right, but I'm just making sure that we're cognizant of these issues that are actually kind of omnipresent across the world. Okay, thank you, Francisco. It's a delight to be here. I helped with Molly Land, found this AI interest group, this tech law interest group at the American Society of International Law, now becoming an AI interest group because of the special concerns about AI in particular. But no, there's lots of other technology issues besides AI, of course. Okay, so to understand the Trump administration, one has to rewind to the Biden administration. Francisco, you're correct that the Trump administration's is not focused on fundamental rights. That framing from the AI Act, as Professor Smuha has told us, is really not the framing of the Trump administration's approach. But it's important to understand the context from the Biden administration. So the Biden administration didn't really throw its weight behind a federal law. And federal AI law. So it didn't try to create an AI Act that would be similar to the European Union's AI Act. Instead, it decided to do things on its own, use its enforcement powers and use its procurement powers and some additional powers related to national security. And so the Biden administration, first, a number of things that I think we should, I'll just walk through a quick chronology to kind of remind people where we are. So in, just choosing a few, I think, really important points in that chronology. In July 2023, the FTC opened an investigation of OpenAI. And so, which is, the leading, US AI company, was subject to a very substantial investigation that, as far as I can tell, is ongoing, though we haven't seen developments in 2025 beyond into the Trump administration. We saw developments in January 2025 during the Biden administration. as a last minute kind of pushing reports out the door of the Biden administration, worried that they would be, reversed or withdrawn in the Trump administration. But in any case, an ongoing investigation of OpenAI by the FTC. And so this is a broad kind of investigation in what data is being used, what systems are being used to test the quality of the product that OpenAI offers, et cetera. So a very kind of significant possibility of an enforcement action at the FTC against OpenAI, which has, so all of this, so the risk-based approach that Nathalie discusses is in fact, in some sense, part of this analysis. And so the analysis is really, are they doing the right things to keep it safe? And so that is the kind of core of the analysis. If they're saying it's safe, are they doing those things to keep it safe? And so then we see an executive order, and this is probably the most famous action by the Biden administration. In November 2023, an executive order on safe, secure, and trustworthy use of AI, development and use of AI. So that is a broad executive order. It is concerned with all the things that sound in fundamental rights. It's concerned with equity, and it's concerned with bias. It's concerned with ensuring access to these things, et cetera. But it's very much a document that is framed with fundamental rights, concerns about the way AI might present risks to ordinary people, and so trying to mitigate those risks. It's not, it's very clever in how it works. It's not a law for the private sector operating vis-a-vis all of us. Rather, it's an effort to use the government's procurement power to influence how AI develops vis-a-vis the world. So it's a clever way to say, hey, when the U.S. government buys AI, it must meet these criteria, and that way, when OpenAI develops AI, which it wants to then sell to the U.S. government and to the American people and American businesses, it will really be comporting with those rules for both government and private sector actors. And so it's a clever way to leverage the government's procurement power to influence the shape of private sector development vis-a-vis the private sector. So it's in some sense a kind of way to do lawmaking without lawmaking, and so it's intriguing, use of this procurement power. Then in September 2024, a year later, the FTC announces 5 enforcement actions against U.S. companies, largely U.S. companies. I'm not sure if all of them are U.S., but I think they're mostly U.S., for deceptive AI. And so it's really trying to say, look, we're out here, we're watching, we're going to penalize you. Including Do Not Pay, which claims to be the world's first robot lawyer, et cetera, et cetera. And so the FTC says, hey, you're claiming to offer lawyering services, but how good are you? Are you as good as a human lawyer at all? And are you kind of blowing smoke in some way? And then, just 2 days before the Biden administration leaves, it announces the AI diffusion rule. And so this is it throws a hot potato into the Trump administration's lap. I would not have wanted to be the Trump administration, lawyers getting this document, because the Biden administration didn't deal with the political blowback from the diffusion rule, because boy, was there a lot of political blowback. The AI diffusion rule said basically the world is divided into 3 zones. friends, enemies, and people who are sometimes friends, sometimes enemies, some people who aren't really entirely to be trusted. Okay. Among the people in that second, many countries that assumed that they were our friends and allies and trusted, suddenly found themselves, oh, we're actually not as trusted as we thought we were. Among those were members of the European Union, Israel, which has a huge kind of supply chain with American tech, the American tech stack. And so a lot of countries found themselves on the, hey, I can't get the most advanced AI models and hardware. And so this AI diffusion rule really kind of was a thorn in the side of relations, of political relations, and a thorn in the side of US tech companies. And the Biden administration, handed it off a day and a half before its last breath to the Trump administration to do damage control from. And so I explained this, and I have a paper called The National Security Internet, which if you want to read about the AI diffusion rule, which I think is just a really fascinating story. You can find a draft on SSRN. Okay, so that is the background. So, political, geopolitical, geostrategic, focused on fundamental rights at home, concerned about especially China getting AI access, and so through the facility of accessing it via countries that outside that gain access to US models. Okay. The Trump administration comes in. It early on has some AI training executive orders. In May, it rescinds the AI diffusion rule without putting in place anything to replace it. So it says we do not want to deal with this mess, and it just repeals it outright. I thought they might fiddle with the way the zones, who was in the zones, to expand the trusted partners, so that it wasn't such a thorn in our side. But it just deleted them entirely. And we'll fast forward to the AI action plan, which really kind of affirms that subsequently. And so when they deleted the AI diffusion rule, they say, hey, this is going to lead to fragmentation of supply chains of AI, which I think is right. And it risks competitive disadvantage vis-a-vis foreign AI players, namely Chinese AI players. So such as, for example, DeepSeek. And so the possibility that Chinese AI models now become adopted across the world as opposed to US AI models. And so this brings us to July 2025 with Trump's executive order. And we'll talk more about this during the course of our back and forth. It borrows the Biden administration's strategy, regulatory strategy, which is, hey, you had your priorities in procurement. We have our priorities in procurement, and they're the opposite. We're going to use this procurement power to reshape AI by saying it can't be, say, woke. We're going to, also promote the export of our AI systems, exactly contrary to the Biden administration's effort to clamp down AI exports. And again, the idea is we want the rest of the world building on our AI systems, not Chinese AI systems, and also kind of rules about vetting systems deployed by the U.S. government for bias. But now bias has a different meaning, which we'll discuss later, and also vetting the Chinese AI systems for bias. which is also fascinating. So I'll leave it at that, and we'll come back to further discussion of what exactly all that cashes out to with woke AI.
Perfect. Thank you very much, Professor Chander. I should mention that this event, we got more than 100 registrations. Right now, we are more than 70 people connected. And I asked through the chat where people are connected from. I can see people from Mexico, Venezuela, Europe, people from India. Questions are arriving. So maybe Professor Smuha, Professor Chander, if you can look at the Q&As, questions are related to our next block, rights, the protection of rights. How can we mitigate bias if this is a technological issue, not a legal issue? How can we improve gender inequality with the use of artificial intelligence? Corporate law, how can we balance corporate law, the establishment of companies in Delaware with the policies of artificial intelligence for the protection of rights? So Professor Smuha, the same year that the European Union Act entered into force, the Council of Europe created a treaty on artificial intelligence, on democracy, human rights, and the rule of law. Can you explain to us why was such a treaty necessary if UNESCO has already put an agenda on the table? And there is also the European Court of Human Rights. There is a very complex legal scenario. You have 27 countries for the European Union that have to comply with the EU AI Act, and 42 countries from the Council of Europe that will have to adapt at least a dozen of them a different legal framework. Could you please guide us through these complexities of the European Union? Thank you.
Sure. Yes, it sounds complicated for those countries, but it's actually simpler than it looks like. So why both the AI Act and the Council of Europe Treaty? Let me first do a quick detour to the AI Act and to say that I agree, of course, with Anupam. There are lots of exceptions to the AI Act, and border control and migration is a high-risk system. So it's, for instance, a technology that falls under the high risks, but then there are exceptions to it. And then there are exceptions to the prohibitions, there are exceptions to the high-risk systems. And the reason for those exceptions is, first of all, you need to find a compromise. And looking at the questions in the chat, there are strong voices countering the idea of regulating AI, especially regulating it rigorously, precisely because of the competition with China, right? So I'm trying to address a question there. And that's why there is this balancing. If you want to regulate something comprehensively, you need to make exceptions. The alternative is that you don't regulate something comprehensively, you don't start broad, you start very narrowly. And then you need to have fewer exceptions because you only target specific things, but you might lose some things along the way. So those are the trade-offs that you need to make. And so the European Union counts 27 member states. And as I said, the AI Act is long and complex. The Council of Europe, just to even our law students in Europe get confused, is not an EU institution, right? So it is a self-standing international organization that counts 46 member states, including all 27 European member states, but also many others. For instance, the United Kingdom, for instance, Turkey, for instance, Ukraine, right? Just to give some examples. So it's far broader than just the European Union. And they've started their exercise of thinking about international legislation of AI at the same time, or even before the European Union. And the Council of Europe's mandate is really the protection of democracy, human rights, and the rule of law. Those are its three pillars. And what they did already in 2019 is they gathered experts from all of its member states, and other countries were invited to the table as well: Israel, the United States, Canada, Mexico, to discuss, okay, when it comes to international law, and when it comes to the European legal order internationally, what kind of existing legislation do we already have? We have the convention, the European Convention of Human Rights, which is indeed a very powerful instrument. And member states have their own, national human rights legislation. But are there potential gaps? Do we need a new treaty? And they did this exercise. I was actually involved in that. I co-wrote a feasibility study looking at to which extent existing legislation already covers the risks of AI that people were concerned about, and to which extent are there gaps. And the conclusion was there are gaps. In order to fill them, we need to have a mix of binding and non-binding legislation, legal instruments. However, this is the important trade-off. If you have 46 people around the table, and it's more than 46, because as I said, lots of other countries, the US, Canada, Israel, Mexico, Japan, the Holy See, and later also Australia, Argentina, Costa Rica joined. The more countries you have around the table, the more difficult it is to have stringent and detailed obligations that everyone will agree on. So we have right now at the Council of Europe an international treaty that is a framework convention. It's not a convention, it's a framework convention. And the name already implies it just gives the framework of what kind of things we want countries to abide by. And the European Union was a member of the negotiations. So they made sure that everything that is in the treaty fully complies with the AI Act. In a way, the treaty can be seen as a very, very, very watered down AI Act. It has the core principles, right? We want non-discriminatory AI. We want AI to protect human dignity. We want transparency. We want accountability. We want safe innovation. We want reliability. You know, there are key words in there, but there's nothing very stringent. Basically, it says every member state or every party that adheres to this treaty needs to take measures internally. It doesn't say in detail which measures to ensure compliance with those principles. It doesn't create new rights or new obligations. It really leaves member states to ensure that they implement these principles in their legal orders. And that was also the way in which even the US signed this treaty. Of course, under the Biden administration, that would probably not have happened today. But it is a victory in the sense that it extends the idea or the ideals of what a society with AI would look like in a way that protects human rights, and extends it beyond 27 EU member states to a much broader group of countries. And it brings it from the supranational level, which is what the EU is about, to the international level, multilateralism. It's basically the first multilateral treaty on the topic. It has by now been signed by 16 countries. And as I said, the US signed it as well. The US was actually a main negotiator, a main actor in the negotiations of that treaty. But signatories are not enough. You need to have countries ratify the convention. And you need at least 5 ratifications before the treaty enters into force. And while 16 countries already signed the convention, 0 thus far ratified it, right? And it was a victory for many countries that the US signed it as well, but there is no chance, at least in the foreseeable future, let's put it this way, that the US will also ratify this convention. And that was evident from the very start. Even under Biden, it wouldn't have been very unlikely, but it did sign it along with many others. What to make of this? So as I said, it's a watered down treaty. It sets out the broad lines, but it's not a completely empty shell, right? There's lots you can criticize about it as well, lots of missed opportunities and potential. But it also has the idea that you should be able to lodge a complaint to competent authority if human rights have been breached by the use of an AI system, for instance. You should know that you're interacting with an AI system and not with a human being. So there are a few snippets there that you also find in the AI Act that are a little bit more detailed. But it has the same exemptions in scope as the AI Act, which Professor Chander mentioned. It does not apply to national defense. It does not apply to national security. And even R&D is exempt from the treaty, although the treaty does say that if your research significantly interferes with human rights, it could fall under it. Now, the big controversial point here was, does it apply only to public actors or both to public actors and private actors? And at the very beginning, before the US was active around the table, that was not even a question. It was evident that since these systems are being developed primarily by private actors, these rules should apply to private actors. But once the US, seriously took a chair around the table, and then you also had other countries, of course, trying to minimize the potential severity of the obligations for companies, again, out of competitiveness concerns, which are understandable in the current geopolitical order, this too was watered down. So the treaty now applies only to the use of AI by public actors or private actors acting on their behalf, but countries can opt in, and they can opt in to also make it applicable to private actors. That was the elegant solution, so to say, to still have a compromise, to still have countries wanting to sign up and agreeing with the content of the convention, while at the same time basically shielding their private actors from having, an additional regulatory burden that might weaken competition. And so it really shows, in a nutshell, how these two competing interests between being, the first in the race to AI and making sure everyone uses your product and making sure you're on top of the race, versus making also sure that human rights are protected, and having different interpretations of what human rights protection means and what the measures are to get there, and balancing those two out. And that is essentially what we see in this convention. As I said, it's still a long way to see if this ever will actually enter into force, but that's what it is about.
Thank you very much, Nathalie. Professor Chander, now let's go back again to the US and the issue of the protection of rights. As you can see in the Q&A, there are a lot of questions on how the US will react, how will it control companies, how will it harmonize legislation at the federal level. Can you explain to us what will the role be of Congress? In the US, there are congressional hearings where the big tech guys, they have to go and they have to explain what is happening. Now there is a scandal on how Meta allowed romantic feelings to develop with children and in their technologies. What is the role of courts? What have you seen? Is there evidence for hope in this area for the protection of human rights in the US? Professor Chandler, please. You have 10 minutes so that we can go back for final conclusions and go deeper into the questions. Thank
Great.
you.
I'll try to be quick, actually, so that we can focus on particular questions if you'd like. So let's just talk a little bit about the concept of discrimination. And so it's been raised a number of times in the questions and the remarks. So here's the difference, and so we hear that the convention will abhor discrimination, et cetera, by AI. But there's a real question as to what is discrimination. And so it turns out that both the Biden administration and the Trump administration are both concerned about discrimination. Okay. And so this is part of the AI. So this is discrimination on the basis of race or sex is to be prohibited by not the Biden administration order. I'm quoting from the Trump administration order. Okay. So, but then the question is, what is discrimination? What do they mean by discrimination? These terms don't define themselves. And you need a much more kind of nuanced understanding of what these different governments mean. Because for the Trump administration, doing things that might harm white people is discrimination against white people. Doing things that might favor women is discriminating against men. That's discrimination, right? So so it just depends on what you mean by discrimination. And so it's very important to use those words and recognize that they can have a different valence depending on who is interpreting them. So let me give you an example of one of the concerns here. I think this is like something like almost 2 years ago now. Gemini, the Google model, released, so when you asked it, draw me pictures of certain things, you asked it, give me pictures of Nazi soldiers, and it would include Black people among Nazi soldiers. Okay, but why was Gemini doing that? Because the model was responding to criticism of Google earlier. Google has long been plagued by arguments that when you ask it questions, it might favor white people. And discriminate against Black people. So it's trying to make its models be inclusive. Okay, and that can of course backfire when you're rewriting history. So it was clearly an error to depict Black Nazis. Okay, so that would be that's not a possibility. Though there is a great Key and Peele sketch along these lines, which I recommend. I recommend all Key and Peele sketches. So now that incident is cited by the Trump administration as a demonstration of, quote, woke AI. That's discriminating against white people. And so we have to recognize the way that these kind of arguments are weaponized. I think we have to be cautious when we use words like discrimination to understand exactly how they are to be interpreted by the powers that be. And so I'll leave it at that. There's a lot more we can say. So the woke AI thing is really just saying again, the procurement side, we want to make sure that they're unbiased. And so the argument is they must be unbiased in two different ways. They must tell the truth, and they must be ideologically neutral. Okay, and to some extent, the truth-telling part of it is uncontroversial. But again, what is the truth then becomes an open question as to how the truth is to be interpreted, right? So I will leave it at that, and we can talk further.
Thank you very much. So before we go to our concluding remarks and our last round of presentations, there is a question on environment and artificial intelligence. This reminds me that in the next month, the Human Rights Interest Group will have an event on the advisory opinions on climate change. So we can include also a reference to that question. There are many questions. Please, Professor Smuha, Professor Chander, go through the Q&A. And in your concluding remarks, maybe you can make a reference to that. Thank you for the explanation on the issue of discrimination. For those who have not read the executive order on the prevention of woke AI, what Professor Chander just explained is the reference that executive order makes to even the examples that happened when Google released these models. So the Trump administration is using examples that really happen to create these ideas that the administration has. So now, Nathalie, can you conclude this event highlighting the main differences between a rights-based approach and a risk-based approach? Maybe not only with the instruments in the European Union and Europe, but in a comparative perspective, if you can. And there are some questions also of bias, how the law can attend inequalities like gender inequalities. So, Professor Smuha, please.
Yes, I'll try to be brief because I know time is running out. So in literature, a distinction is made between risk-based approaches to AI regulation and rights-based approaches. And in a risk-based approach, you acknowledge that there's no zero risk. So the question is, which type of risk is acceptable and who decides what kind of risk is acceptable? And you have risk categorizations. The question is who decides which system goes into which category. And then the question is, how do human rights play a role in that at all? Because if all you look at is a cost-benefit analysis of, oh, there might be a risk, but look at those benefits, you could put under the same level economic benefits to one group versus risks to another group. And should you even put human rights to the same level as certain economic benefits, right? Especially human rights that are absolute, for instance. So this is where a critique of the rights-based approach comes in. But rights are also complex social constructs, right? They're principle-based and they can be interpreted in different ways. And I think our conversation just now showed that you could even reframe the right to non-discrimination in a very different way. So probably what you have in Europe and what you will have across the world is a mix of both, right? Even the AI Act, which has a risk-based approach, takes into account human rights to determine what is a risk or what kind of systems pose a risk. To the previous works of the high-level expert group on AI, which inspired the AI Act, the principles on the environment have been kind of cut out or watered down. And I think by definition, this could be a very good topic for more international cooperation. And this is where we need multilateralism and international cooperation rather than just individual countries working on this. So hopefully with international environmental law, this could pave a way forward. And perhaps before I hand it over to Professor Chander, I think one important takeaway that I think we should all take into account when we talk about AI and human rights and when we compare Europe and the US and China, etc., is that talking about the way in which we should protect human rights in the age of AI actually presupposes that you have governments, that you have institutions, that you have citizens who care about the protection of human rights, democracy, and the rule of law in the first place. And in the EU legal order, these three things are together. You can't have good protection of human rights if you don't also protect the rule of law and if you don't also protect democracy, right? This is the way they approach it. And especially, leaving AI aside, if you want to have a good protection of these elements, they all need to collaborate together. So if you have a disdain to the rule of law, it will also be very difficult to enforce any legislation that is prone to protect us against the risks AI poses to human rights. So even more importantly, I would say, than adopting legislation that protects human rights in the age of AI, we need legislation, we need institutions, we need mechanisms that protect human rights more generally, that protect the rule of law. And you need an ecosystem of institutions and people that work towards that. Because if you don't have that as a foundation in the first place, I think we should not be naive that there also won't be protection against the risks that AI poses to those core values. I'll end with that.
Thank you very much, Professor Chander. One of the questions raised the issue of copyright. The music industry, the newspapers in the US, they have been fighting these battles in courts. Please, in your final conclusions, any reflection on the rights-based approach and the risk-based approach, or a particular right as property rights? Professor Chander?
So one of the things that, so to understand the American regulatory landscape for AI, you have to understand, for example, copyright law. And so right now, all the big AI companies and small AI companies really are facing copyright lawsuits. Not all of the small ones, but all of the big ones at least. So, huge lawsuits for the New York Times has a lawsuit against OpenAI, seeking billions of dollars in damages. Anthropic, Meta, all of these companies face enormous lawsuits right now. So from that perspective, there's real law regulating these companies today. The other thing to note is that there's a lot of state law. So what has happened, less at the federal level, more at the state level, is a huge thicket of laws that are targeted on particular things. For example, identifying whether or not something is a bot. California has had a bot disclosure law now for a number of years, but now there's more and more of these kinds of things, et cetera. So you've seen, and so this question then raises the kind of whether or not there should be one law for the country versus lots of different laws across the country. And Professor Smuha began her remarks by talking about the desire at the European level to have one European law that would that would reduce the regulatory burdens of 27 different laws across the member states. And that question is still a live one in the United States. An effort to create a federal preemption of state laws was defeated partly because there wasn't an alternative, a federal law that was proposed. It was simply to clear the thicket as opposed to decide what the federal standard should be. I think the proponents thought it was too early to have a federal standard, but whatever the wisdom of their approach was. One of the questions that's been raised in these comments by persistent anonymous attendee is the question of discrimination. And you have to look at US con law. US con law treats discrimination against white people as discrimination. I just wanted you to know that's, so we have affirmative action decisions, as you know, affirmative action was just ended by the Supreme Court in higher education, in most higher education scenarios, et cetera. So, you may have your view of what international human rights law obliges, but US constitutional law is extremely important factor in how these things work. And in fact, discriminating against white people is certainly discrimination under US law, period. And so statutory, constitutional, et cetera. And discriminating against men is discriminatory. So these are, I'm not speaking to how they're interpreted elsewhere. My point was, these are the ways that these laws are written. They use the same words. You may want to think about whether or not they have the same meaning in different contexts. Finally, the environmental question. One thing I want to caution is that a lot of people want sovereign AI. They say, hey, we should be running our own AI. That means building out huge data centers in lots and lots of different countries, often with not the greenest energy sources. And so the proliferation of data centers across the world to satisfy demands for data localization, for digital sovereignty, has that kind of negative environmental effect, which may be perfectly acceptable to people because of the importance of digital sovereignty, but it's something that needs to be thought about. Thanks very much. Great to see some of my friends in the audience. Hi, Mira. Hi, Vivek.
Thank you very much. So with these comments, we will conclude our event. We had more than a dozen questions. We will send them in writing to the speakers. They have already read them, but we will make sure that they get them. To finalize, I will have to say that we could make an event on every point that was raised in the questions. There are too many aspects of artificial intelligence and rights and how it affects our life. As a final recommendation, not only for the legal profession, everybody has to embark in digital literacy. There is too much information, it's moving too fast, so we have to get up to speed and learn the terminology, the legislation, and how we can contribute to a solution. Thank you very much, and see you in our next Human Rights Interest Group and Technology and the Law Interest Groups events. Bye.